My name is Jordan Baller. I have the honor and privilege of serving as Director of Research at the Center for Religion, Culture, and Democracy at First Liberty Institute. And it's also my honor and privilege to serve as moderator for this session, which is focused on the Religious Liberty in the States project. The format will be as such after these brief minutes of introduction. The director of the project, Sarah Estelle, will introduce it, followed by comments from our esteemed panelists, followed by some further comments from Sarah, and then we'll open it up for Q&A and further discussion. So let me go through and just introduce all of the participants in this session right now. Starting first with Andrew W. Gould. He's senior counsel at First Liberty Institute, and before coming to First Liberty, he served as a justice on the Arizona Supreme Court from 2016 until March of 2021. Prior to his service on the Supreme Court, he was a judge on Division I of the Arizona Court of Appeals from 2012 to 2016, and as a judge of the Superior Court of Yuma County from 2001 to 2011. During his judicial career, Gould authored over 400 opinions, including Brush and Nib v. City of Phoenix, which held that the city ordinance compelling Christian business owners to create custom wedding invitations for same-sex weddings was unconstitutional. Next is Mark David Hall, who is Herbert Hoover Distinguished Professor of Politics at George Fox University, and he's currently serving as a visiting scholar at the Mercatus Center, a Garwood Visiting Fellow at Princeton University's James Madison Program, and a Senior Fellow at the Center for Religion, Culture, and Democracy. He's the author, most recently, of Proclaim Liberty Throughout All the Land, How Christianity has Advanced Freedom and Equality for All. That's forthcoming, but I happen to have a copy in my hands that he just brought me, so this is a copy of Mark's latest book. Next is Matthew P. Cavadon. He's the Robert Poole Fellow at the Center for the Study of Law and Religion at Emory University. And following graduation with a JD and MTS at Emory, he worked as a Constitutional Fellow at the Institute for Justice in Arlington, Virginia. He assisted with constitutional litigation, especially in cases involving civil forfeiture. He then clerked for the Honorable Lisa Godby Wood of the U.S. District Court for the Southern District of Georgia in Brunswick, Georgia. And following this, he served as assistant public defender in Gainesville and Dawsonville, Georgia. He's worked as a trial, appellate, and juvenile attorney on cases ranging from truancy to murder. Most recently, Cavadon clerked for the Honorable Nels S. D. Peterson of the Supreme Court of Georgia. Thanks to all of these panelists for coming to offer their comments, and it's my distinct pleasure to introduce now Sarah Estelle. Sarah Estelle is Associate Professor, although recently promoted to Full Professor of Economics at Hope College. Congratulations. Because she believes that economics can be useful everywhere and be used by everyone, she enjoys extending the theories and empirical techniques of microeconomics to questions located along the imperialist frontier of economic research. For example, Professor Estelle has published work on criminal justice reform, higher education, risky adolescent behaviors, and parents' investments in children. She is, most notably for the purposes of our session this morning, Director of Religious Liberty in the States, a brand new statistical index that measures the legal safeguards for the free exercise of religion in the United States. And it's my pleasure to introduce her, and she's going to introduce the project. Thank you.
I'm really excited to be here. Ciceronian Society meetings, again, I've been looking forward to it for a year since the last successful meetings. Thanks for everyone who makes that possible. And especially to introduce this project to this particular group. We're really interested in seeing what scholars will do telling stories with data. We hope this project will illuminate some really interesting stories that there are to be told. I'll start right off the bat by saying that the full report associated with this project is available on our website, religiouslibertyinthestates.com, and also in the lobby area in a printed form. And so I want to tell you about what this project intends to do and how I think it can serve as a launching point, and I hope even as some inspiration for research from many, many others. I look forward to hearing the comments again from our esteemed panelists who will be able to flesh out a lot more than I as the economist will do in this short presentation. But the goal of this project, my initial charge, was to construct a statistical index that could be used to measure the interstate variation in the United States and what these localities are doing to establish protections, or what we call safeguards, of the free exercise of religion. And so measuring things in a credible way is key, right? In a way that we can communicate across differences and people will believe that we're measuring what we've set out to measure. This is animated by a spirit of positive pluralism, as I've been calling it. Not just that we do live in a diverse society, but that there's something positive to be enjoyed in a pluralist society, especially where people's liberties are respected and protected. In order for the measure to be credible, we wanted from the very beginning to set out with objectivity as one of our key principles. And in order to argue that this project is in fact objective, we have been extremely transparent in all of our decisions, hence the full-length report that's available, again, in the lobby. And even a full data set that explains all of our discernments and assessments of each of the data points that goes into the aggregation that is the statistical index. I think for the purposes of folks in this room, it will be helpful to know that it's not just quantitative data that we're providing. In fact, the way we come up with our quantitative measures is by reading a lot of laws, at least 1,500. And that is a large bulk of the work that's gone into this project. And so what we're providing to people is not just the scores as to whether the safeguards exist or not in a state, whether those protections are there, but actually a simplified coding of the very letters of the law, and then ultimately the statutory citations and hyperlinks to the laws that we assessed. And so I imagine that a number of people in this room will be far better than I at digging into the details there and making something else out of what we've tried to summarize in the form of a statistical index. But in order for you to want to do that, or to buy even what we're doing in this project, I want to tell you a little bit more about our methodology. So first, I have to give an enormous amount of appreciation and credit to the Center for Religion, Culture, and Democracy for granting me just the ideal academic freedom. I've never experienced such academic freedom as I have in this project, that there weren't intended outcomes or ultimate stories to be told at the front end, but really a desire to use the best practices of my discipline, economics, to think carefully about measurement. And so integrity for this project has been key. One way that we have approached the project with that integrity in mind is not to come with a kind of defined set of issues or topics that we think religious people care about, where religious liberty should be found, but rather within the project we're allowing states to speak. And what I mean by that is they're revealing in the letters of their law where they see that their citizens will find value for safeguards of free exercise. And so in practice what we do is where we see a state identify, let's say, an exemption or a refusal right or an opportunity as there for religious concern, we identify that as a potential safeguard that all 50 states could consider, and then we look at all 50 states and note which ones have those safeguards or something comparable in place and which ones do not. Ultimately, in this way, we're allowing states to define the frontier, right? Maybe not the ideal, many of us might like to push that frontier further, but the feasible frontier of what states can do to safeguard the free exercise of religion. So then we focus on statutory law. Because of the need for transparency and objectivity, we want to make sure we're assessing things that other people can assess as well, right? There is a bit of crowdsourcing here ultimately in this annual project, that we're so open to feedback and we're learning a lot, including from various state legislators and committees in different states that are telling us, hey, we're pursuing this or we're interested. Why wouldn't you think that this particular line in our law accomplishes what you have in mind? And so it's been very helpful to have that sort of feedback. Likewise, we're looking forward to feedback from folks like you and scholars in general. And so we're focusing on statutory law, fully recognizing that the courts get to interpret law, the executive branch gets to enforce laws in various ways, and so we're never going to define this project as something that is all-encompassing. Right? We're trying to measure a particular thing that we think is quite important, right? It gives legal standing to religious people in courts of law, and that's what we set out to measure carefully. To do that, of course, we're focusing on where there's variation, differences across states, but we do need to be aware of the federal context. There are laws on state books that are no longer really current, right? That they've been superseded by federal bureaucratic decisions or court rulings or legislation. And so we need to be aware of that in order to understand what really is varying across states. We have taken the step of carefully defining, we think, liberty. One man's free exercise looks to other people like establishment. I don't think that that is actually the case, but we run the risk of looking like we're looking for religious privilege if we're not careful about what we mean by liberty. And so I've taken the approach, some might be familiar with thinking of freedom from as opposed to freedom to. We think this is consistent with the real spirit of the First Amendment of the federal Constitution that says Congress shall not. And so we're looking for ways that states are in fact constraining themselves, where they're removing artificial barriers that they have put on their citizens, as opposed to the inter-citizen sorts of things. And certainly we're not interested, at least for this project, in the freedom to, although I suspect many people in this room understand that freedom is really valuable for what it allows us to aspire to and work towards, right? Freedom is a means as opposed to an end in that sense, but we're measuring the freedom from the state itself. So we read all of the laws that are necessary to understand the various dimensions of statutory safeguards that we've identified in our search. We code them with letters. I think many people will find those useful. The letters indicate the ways that the states are accomplishing these safeguards. And then ultimately we have to quantify that so that we can aggregate across the 11 areas that we're interested in. And those scores, 0 and 1, represent whether there's a safeguard in place that is a 1 or not. And so not having a preconceived notion of what really should matter to religious people, and certainly wanting to make this project meaningful and accessible to people of all faiths and no faith at all, we turn to the states to see what issues arise where there is mention of religious exemptions or opportunities for accommodation. And we identify 6 topical areas that we call groups. Really 11 safeguards when we look at who is protected and in the course of doing what and from what they're protected. Those are our 11 safeguards. And then some of those safeguards require more detailed analysis. There are a number of dimensions over which states differ in their provisions for those protections. So I'll give us a couple examples. I hope this is large enough for you all to read. One of the simpler safeguard areas, which is absentee voting, we're interested in because we see a number of states noting that people of religious faith may find it difficult to get to the polling place on a religious holiday. And so is that an acceptable excuse for absentee voting? There are a number of ways that states accomplish this, either by allowing it to be an acceptable excuse or making absentee ballots available to people without excuse, or even all-mail voting would accomplish the same thing, and we count those as safeguarded. But states that give no recourse for folks that wouldn't be able to make it to the polling place on election day get a 0. The thing is, it's pretty simple to quantify and to locate in the law. It's either there or it's not. Now, this is quite different from the abortion refusal rights that many, many states offer to religious healthcare practitioners, where there are actually 7 dimensions that we have to pay close attention to understand the extent of the safeguarding. Most states allow for individual healthcare practitioners to refuse participation in abortion. Many will allow private hospitals to refuse to perform abortions in their facilities. Some allow for public hospitals to do the same. So already you hear there are 3 dimensions. Then what are these folks protected from? Is it civil liability or criminal liability claims? Is it the repercussions of the government instrument, particularly licensing and the like? Those are 3 more dimensions. And finally, some states will limit the refusal right in the case of a medical emergency. And so we've taken great care, I hope, in noting that there are differences in those ways as well. And that's why we have 29 items in total that constitute these 11 safeguard areas. So I explain this mostly to suggest that there has been a systematic approach to how we're measuring these things. I think data only matters or means anything if we know where it's come from. And there's much more to be said on that, but I do think folks will find the data themselves interesting. So I hesitate to call these results in some sense because they are rather surface, but I think there are a number of important takeaways we can see if we just look at the scores across states. So again, aggregating across the 11 safeguard areas, considering the 100% mark, the frontier, if a state had done all of those things. The first takeaway, sorry, I have to give a graph. I am an economist, they'll take my card back if I don't do it. We're looking at the distribution of states here. What percentage of safeguards do they have in place and how many states are in each of these positions? You'll notice there's room for improvement for everyone, right? The top two states are up there at 81 and 82%. Right? The vast majority of states are giving less than 50% of the statutory safeguards that are clearly feasible as demonstrated by their peers, right? And 50% of states are giving 33% or less of those safeguards to their citizens. So one takeaway is that there is a lot of variation, but where there isn't variation in some basic sense is there's room for improvement. And so I hope this inspires people's activities as thoughtful citizens. But I'm also interested for those of us that are into working with data, and I don't just mean numbers, but the laws themselves. If we see those as data, what can we learn? And so here's another view on that data, a heat map of sorts, where a darker blue represents more safeguards being implemented in a state. If the image is big enough and the color distinction's clear enough, you can really home in on those top two states. With 82% of the safeguards, Mississippi came in number one. But surprising to many, Illinois, with 81-point-something%, really on the tail of Mississippi, was number two. Fascinating. The lightest colors you'll see with California, West Virginia, and New York, around the 16% mark, all three of these lowest states. What you'll notice just on first glance is this is not a red and blue distinction, right? The typical red-blue divide is not exhibited here with these particular statutory safeguards. And so you can find your state on the map and get a rough idea of where it fits into the overall ranking. Let me save for later on other ways that you can learn about this, but I'm most interested in hearing the feedback from the panel and your questions later. Thank you.
So first up is Andy Gould, and let's welcome him to give his comments. Thanks, Andy.
Thank you. Well, thank you. When Sarah mentioned mail-in balloting, I come from Arizona, and it made me cringe a little bit. We don't know how to count votes in Arizona very well. One of the things that wasn't mentioned about my resume was a failed candidate for Attorney General in the 2022 cycle, and I spent a lot of time on the ground, so it's like an open wound for me when you mention mail-in balloting. I've spent 33 years in the law, and I've watched the changes over time, and I really do believe that the issue of our time in terms of the law is federalism. It's the 10th Amendment. It's the power of states in terms of basic fundamental rights and their interaction with their citizens, and of course religious liberty is at the forefront of it. Whether you like it or not, and people don't like it when I say this, but this is a fact, all the important issues of our time, sooner or later, wind up in court. Now that's not the way the Constitution was designed. It was supposed to be Congress and the legislature. That's a better way, I agree, but that's not the way we do things in this country. And that's in large part because Congress, state legislatures are in gridlock. They're not getting things done. They're not getting out in front of problems. People get frustrated and they go to the courts. And the model that they follow is basically the model that was designed to break down segregation in the South. Legislatures weren't acting. Segregation was eliminated through the courts. And that's a model that people have been following now for the past 50, 60 years. So when we look at state courts, I think there's a couple of very important issues on the horizon for religious liberty. Dobbs is a huge case. And as you know, Dobbs has now taken the issue of abortion and it's turned it back to the states. And so what do we have now? We have state Supreme Courts are going to be responsible for construing and interpreting their state constitutions, statutes on bans or restrictions on abortion. And we see this already. There is a plethora of litigation out there now, all in the states, and it can be from state provisions on privacy. Some states have a right to privacy written in their constitution. Arizona does. It's Article 2, Section 8. It can be the state's due process clause. Some states have a liberty provision that's construed very broadly. Oddly enough, some states, like Ohio and Wyoming, to push back against the Affordable Care Act, passed an amendment and put in their constitution a provision that you have a right to choose your own health care options. And now some have picked up on those constitutional provisions and said, well, that includes the right to have an abortion. So although that wasn't the original intent of those provisions, it's now being used as a means to protect the right to abortion. There are a number of lawsuits right now in the country where religious groups are using the free exercise provision in a state constitution to protect abortion rights. And the argument is, and this is in Indiana, there's a case that's pending right now, but in other states as well, the argument is, well, my faith says that I shouldn't do anything that causes physical or emotional harm to another person. And so there's some groups, Jewish groups, all types of universalist groups, they're bringing lawsuits saying, yes, free exercise protects my right to have an abortion, and they're using state RFRA statutes to enforce that right. Another huge issue on the horizon for state courts is free exercise. Originally, it was the states that protected free exercise. It was a state issue. In fact, it was always a state issue, with a few exceptions, up until the mid-20th century, and then the Supreme Court started getting involved. And eventually, the Supreme Court created a very protective jurisprudence of free exercise with strict scrutiny and looking at cases on a case-by-case basis. And so that was developed, and what happened was state courts drew back from construing their own constitutional provisions. So for decades, 70, 80 years, state courts have said nothing about it. They've just applied the federal model. Well, over 30 years ago, the Supreme Court issued the Smith decision, which essentially wiped out that protective basis for free exercise. And Congress acted, they passed RFRA. That doesn't apply to the states, so some states have come up with their own RFRA statutes. But the issue now is, will states start enforcing, or will state constitutional provisions protecting free exercise now be livened up? And the hard part about that is, state Supreme Courts in particular have been so dormant on this issue. They've relied on federal law, First Amendment cases for so long, they haven't developed their own jurisprudence. And so now what's going to happen? Are state courts going to step back out and try to enforce these state provisions? I'll give you two quick case studies about the impact of a state Supreme Court on religious liberty and First Amendment issues. The first is the Goodridge case from Massachusetts. It's a 2003 case, and it's a same-sex marriage case. This is the case. When the Massachusetts Supreme Court issued this decision, it's what launched same-sex marriage statutes, case law. In fact, if you read the Supreme Court's decision in Obergefell, it adopts the basic rationale of the Massachusetts Supreme Court in Goodrich almost step by step. This case has been cited over 4,000 times. It's been cited in 25, 30 states, numerous federal courts. The point being is, when this case was issued in 2003, it had a profound impact on the same-sex marriage debate. Another example, and I'll close with this, and if you think that I wasn't going to talk about a case I wrote, you're sadly mistaken. In the Brush and Nib case, the case I authored, it was a challenge to a City of Phoenix ordinance, a public accommodation law. There's a public accommodation provision in the Civil Rights Act, there's state public accommodation provisions. The bottom line of public accommodation laws is you can't discriminate based on protected status. You can't refuse to serve somebody because of their race, and many cities have incorporated in sexual orientation, gender identity, and the city of Phoenix has done so as well. I think now that the Supreme Court has issued the Bostick decision, it's embedded also in the Civil Rights Act. But in any event, in that case, they were the plaintiffs were two wedding invitation makers. They did custom wedding invitations. The city ordinance was going to be enforced against them. It was a pre-enforcement action, but they were poised to enforce it against them because they refused to create custom wedding invitations to celebrate same-sex weddings. And so the issue was a free speech issue versus a conduct issue. And of course, you've read about all these cases throughout the country. There's a lot of nuances to them. There's a couple of cases in front of the Supreme Court right now. 303 photography is the big one right now. But this case in my court was brought on state law grounds. It was brought under the state free speech provision and the state RFRA law. And the problem that we encountered, and I don't like to give too much of how the sausage is made behind the scenes, although I suspect I'm going to be asked about that, is the state constitutional provision for free speech is much broader than the First Amendment, but we had not developed any jurisprudence since statehood. And so we were left with the First Amendment jurisprudence. Ultimately, we upheld the free speech right, but that basically lays out, and it made it very clear to me, the challenge that state Supreme Courts have in this new era in terms of having to interpret those state constitutions. So with that, thank you very much.
Thank you, Andy. Next is Mark Hall. I'm going to call up here. Yeah, thanks. And I'll do the same thing. I'll put at 5 minutes or 2 minutes or whatever. I'll put a little timer up there.
Excellent.
Oh,
Are you going to beep at me as well?
Well, it might if I don't get there in time. Yeah. Sorry.
All right. Well, I think my comments, I'll try to make them fit and go along with Andy's. So first of all, thank you to the leaders of the Ciceronian Society. I've known of this organization for years and years. This is the first time I've ever been able to come to a conference, and it's wonderful. It's far superior to things like the American Political Science Association convention. Thank you as well to Jordan and CRCD. I've loved working with them over the last year and a half or so in some detail. I've bothered poor Sarah too much already with suggestions for how the study might be crafted, for new things they might want to look at, and I think it'd be a little too in the weeds to reiterate those here, so I'll just leave that to the side. I thought I would really emphasize what I really like about this sort of study, and it's based on my own experience, and I'll talk a little bit about my own work because I think that might help shine some light on what religious accommodations look like and how they can be crafted and why they would be crafted to begin with. And that's what we're talking about here, religious accommodations by and large. So over the last 200 years, the chief threat to religious liberty is not laws targeting particular religious traditions. You don't have laws saying Native Americans can't use peyote in religious ceremonies, or Jehovah's Witnesses must salute the American flag. States aren't passing laws like that. What they do is they pass general laws of neutral applicability. No one gets to use peyote. Everyone must salute the flag. And the question then becomes, what do you do when these laws that I think oftentimes in good faith, they're not aimed at religious minorities, what do you do? Historically, I think there's three kind of obvious answers. The one that is done in far too many countries is you say the law is the law. Follow the law, right? Another option, though, might be to say, well, we don't want to burden any religious minorities, so let's get rid of the law. But if the law is there for an important reason, we don't want people to use narcotic drugs, you might not want to do that. The best approach, I think, is to craft a religious exemption or accommodation, such that you say, okay, yeah, generally people in Oregon don't get to use peyote, but if you're a Native American, and actually when they revised the law, they said anyone who believes they need to use peyote in a religious ceremony, Native American or not, you get to do that. Now, this is a very sensible approach to protecting religious liberty and still allowing the state to pursue important policy objectives. Religious accommodations have come under severe assault over the last few years. Marcy Hamilton, Brian Leiter, Micah Schwartzman, and others are saying, no, we ought not to have religious accommodations at all. Just recently I saw, I forget the guy's name, but a law professor that argues, well, it's okay to have religious accommodations to protect religious minorities like Native Americans, but they shouldn't protect members of the majority, by which he means Christians, right? So we'll protect the Muslim, the Jew, the Hindu, the Sikh, but not Christians. Literally, he's arguing this in a major law review article. So what are the arguments they make? They're oftentimes, and no offense to those of you who've gone to law school, but law professors like doing hypotheticals. I literally saw this in the state of Washington. Imagine you have a grocery store, and there's not another grocery store within 100 miles, so we're talking about Eastern Washington. And the grocery store owner has a religious conviction that he should not sell food to same-sex attracted people. Wouldn't that be horrific? That would be horrible, and obviously we can't allow that, and so we can't allow Barronelle Stutzman, the florist in the Tri-City area of Washington. We can't allow her to refuse to participate in a same-sex wedding ceremony because then the sky would fall. This is a sky is falling argument, right? So I was actually an expert witness in that case for a different legal advocacy group, which will remain unnamed. The plan was to actually have a jury trial. And the attorney for this other group said, look, the other side is going to argue we cannot possibly give Barronelle Stutzman a religious accommodation because the sky would fall. And nobody wants this sky to fall, so too bad for Barronelle Stutzman, the law is the law. And so what he asked me to do, without telling me what to do, he said, look, we've been doing religious accommodations in the real world, not in law professor hypotheticals, but in the real world. We've been doing this from the earliest colonial times. And I'm not a real social scientist, even though I kind of have an appointment in political science. I'm a historian. And so I took a historical approach to this. I looked at all sorts of areas of religious accommodations, and I asked the question, does the sky fall? I began with one that I think is maybe the most obvious, national defense. So from the early colonies, and in the early colonies, things were touch and go sometimes, right? You had a lot of Native Americans who weren't thrilled with these white people, and you had relatively few white people, and so every colony had militia requirements. Basically, young men get to serve in the militia. They have to serve. They don't get to serve, they have to serve in the militia. And so this is a requirement, and of course, we continue to require people to serve in the military up through the Vietnam War, I guess. And we'll talk about that a little bit. What I want to suggest, though, is again, you have this problem. Okay, what do you do? Well, because you got Quakers and Mennonites and Brethren who say, we have religious convictions that say we cannot serve in the military. Well, one approach is to say the law is the law. Serve or else. You go to jail, something like that. Georgia took that approach. Georgia was created as a buffer state between Spanish Florida and South Carolina. You had some poor Moravians who moved to Georgia. And when it looked like the Spanish were going to attack, the Georgia authorities were going around rounding up everyone and say, all the men, and say, you will serve in the militia. And the Moravians said, we can't do this. And so, what do you do? And Georgia came down with the hammer of the law, too bad for you, Moravians. And eventually the Moravians just left the state and went to Pennsylvania, right? So the law is the law, That is one approach. Let me point to a remarkably progressive, in the best possible sense of the word, statute in Rhode Island, and I'll use this to suggest what a lot of other colonies did, which was actually not quite this good. Rhode Island, as early as 1673, had a statute that says no person or persons within this colony who have been persuaded in their conscience or consciences that he cannot and ought not train, learn to fight, nor go to war, nor kill any person, this person shall be let alone. I'm skipping a lot of language. We aren't going to prison him, we aren't going to shoot him, or that sort of thing. And no, this is really a pretty amazingly progressive statute. Let me jump to one important requirement, though. Because you have this religious conviction doesn't mean you get out of duty free. It goes on to say that you religious pacifists will perform a civil service to the colony. For instance, conveying out of danger women, children, goods, cattle. So you still have to serve. We'll just permit you to serve in a non-militaristic way. So I would say this sort of religious accommodation is excellent. If you listen to that carefully, I kind of wish I could put up here, one of the striking things about this is Rhode Island did not limit its religious accommodation to specific denominations. Almost every other colony did. They would specifically say Quakers don't have to serve in the military. Mennonites don't have to serve in the military. So very unusual in this respect. As well, it protects non-religious pacifist, which again is very unusual. Almost always, and to this present day, the U.S. Code only protects religious pacifists. There were some goofy cases of statutory interpretation in the 1960s that kind of expanded that as a matter of goofy statutory interpretation, but the U.S. Code still clearly and only protects religious pacifists from being forced to serve in the military. One of the nice features of this early Rhode Island statute is you don't have to hire a substitute, which became a very common way of protecting religious minorities. This, of course, was viewed, and I think it is unfair, right? Rich people can hire substitutes, poor people can't, and so poor Quakers are left out. Let me just real briefly zip to the present day, more or less the present day, World War I. World War I, I think Sarah mentioned briefly, Establishment Clause challenges to these sorts of things. The Selective Service Act basically required everyone to register for the draft, but it specifically held that members of historic peace churches, Quakers, Mennonites, Brethren, who are religious pacifists, get to do alternative service. Now, keep in mind that we're talking about privileging religion, right? So this would seem to privilege members of historic peace churches. The U.S. Supreme Court eventually heard this claim in the Selective Service Act of the Selective Service cases, Arbor versus the United States, and basically the court said, and we pass without comment the absurd claim that exempting religious pacifists is somehow an establishment of religion. And basically 7 or so such claims have come before the U.S. Supreme Court. In all but one, which was a horrible decision, in all but one they've said, of course, it does not constitute an establishment of religion to protect religious minorities. I keep saying religious minorities because it just happens to be the fact that it's only religious minorities who run across these sorts of laws. Now you might object, what about someone like Beryl Stutzman? She's a Christian, and Christians are the majority. But even there, I think it depends on how you slice and dice it, right? She's a Southern Baptist, that's a kind of tiny minority. The organization for which I was working surveyed every florist in eastern Washington, and she was the only one who had a religious objection to participating in same-sex wedding ceremonies, and so you could call her a minority of one. Let me just close this up by saying, fortunately from my perspective, the Selective Service Act of 1940 broadened the religious accommodation to protect all religious pacifists. We could talk more about that, but yeah, so the connection, getting into the real world, studying real life religious accommodations, getting away from these law professor hypotheticals, I think can show, and we can now look at these states, right? We can say, okay, look, Mississippi has lots of religious accommodations. Is the sky falling there because of all these accommodations? And I think what we would find is no, it's not. And so let's work with real world data, be it historical or social scientific, and not law professor hypotheticals. So with that, I will stop. Thank you.
Thanks very much, Mark. Thanks.
I'm here to provide 10 minutes of annoying law professor hypotheticals. Now, when I was listening to Abbott Placid's talk last night, it made me think about parallels between a federation, such as the Benedictine world, and federalism, and some of the trade-offs that you get when you try to look at things from the airplane level view versus when you dig down into the granular details. So what Professor Estelle has done, I think, is the equivalent of trying to suss out the rule of St. Benedict. Very helpful. Tells you a lot of very interesting things. In 71 chapters, you get a lot of information about a lot of differences, right? But you also heard from Abbott Placid that if you really want to know what's going on inside any given Benedictine community, you've got to look at its particularities, because rules change. Because even what's written on the paper might get dispensed with, because there's all sorts of wiggle room, right? And that's part of the life of a community. So first of all, I want to start by applauding the turn to the states. As Justice Gould talked about, there's long been a bias within academic research, certainly within the lawyerly world, that the federal stuff is really the good stuff, and it's the only thing that matters. State Supreme Courts went to sleep for a fairly long time because federal courts were where all the action seemed to be. That is changing. There have been pushes over the past couple of decades to return to the states as major sources of law and norms. That actually started not on the conservative side of the spectrum, but with Justice William Brennan, who was one of the most left-leaning members of the court. His opinion was that, look, the federal Constitution protects a certain amount of liberty, but you have 50, 51, 52, if you want to include Puerto Rico and DC constitutions that overlap. And folks like Justice Gould, when he was on the bench, have every prerogative to interpret those constitutions differently than the federal one. So what Justice Brennan thought was, the federal Constitution sets the floor, but smart advocates should be looking to the states to try to raise that up higher to provide more protections. That's been echoed in recent years by Judge Jeff Sutton on the Sixth Circuit Court of Appeals. He's a federal judge. Nevertheless, he has a deep respect for what he calls 51 laboratories of democracy, all these different places where those debates can happen. That is healthy for a democracy. We're here talking about places and things divine, right? Place, community. Those are sites where people sit down and disagree in a way that's intelligent. And hopefully, if there's a sense of neighborly love, which is a thing divine, and love for your enemies, which is a thing divine, states should be a place where people figure out how to adjust norms to their particular conditions and how to listen to each other in respectful ways. To take one example, Utah, a few years ago, was debating whether or not to include sexual orientation and gender identity in its state anti-discrimination laws. The Mormon Church and leading advocates of that view sat down and hashed out a very impressive statute protecting a wide amount of religious exemptions and protecting gay people from getting fired by Target because they're gay. So that sort of compromise, that sort of civility, I think speaks to what the Ciceronian Society and what the Institute are all about, right? Which is that embeddedness in a community and respect for one another is important and is vital for a free society. Now I think I need to do a little bit of professional defensiveness here, otherwise the economists, the political scientists, and the robots are going to take our jobs. They're just going to plug in a bunch of numbers and come up with a letter grade and say whether or not you win or lose. What is the point of lawyers here? Professor Estelle was very straightforward about how there are trade-offs involved in trying to reduce things down to nice, objective measurables. Let me suggest, by way of, again, existential anxiety for the poor attorney, and by way of crowdsourcing, some things that perhaps the empirical folks can look into more. Some of those softer, squishier places that might deserve a look. What is written in a law, what is written in a religious rule, only gets you so far. What you need to do is drill into jurisprudence. How has that been interpreted? What does it look like on the ground? The legislature may have primacy of place in setting out what those rules are going to be, But the courts certainly have a tremendous amount of power in terms of defining how much it means in practice. So we heard about RFRAs, Religious Freedom Restoration Acts. All of those specify a balancing test where a government can override a sincerely held religious belief in a way that substantially burdens somebody if the government has a compelling interest and no narrower way to pursue it. What does that mean? That's a trick question, because what that means in any given context, what that means to any given judge, is going to look different. You can have all the RFRAs in the world, you can have all the exemptions in the world, but at the end of the day, all of them, no statute says, if you show up in court and you say you're Presbyterian and you can't get a vaccine because you're Presbyterian, you don't have to do the vaccine. None of them spell it out that broadly. There's always sifting of government interests. There's always testing of the sincerity of the people who are appearing before the court. There are live questions all throughout the country about what is religion. Yeah, about whether an atheist counts, about whether a Thoreauian counts, about whether one Southern Baptist who has a particular quirky reading of sexual ethics in this particular context around selling flowers, right? That all comes down to the granular. You cannot write a law reducible to a neat objective measure that covers all of that. These all depend on tradition, on traditions of judicial interpretation, on traditions, discourses, conversations that have already happened. Here, a quick flight of other topics where there's some wiggle room left by the federal government, and therefore there's all kinds of messiness in the states. Some of them are freedom from government action, some of them are freedom to, and some of them don't quite neatly map onto either of those. As far as freedom from goes, prisons. There is a federal statute protecting strict scrutiny for religious claims involving prisoners. I would say that that's freedom from, because the government is forcing you to live inside of a nice, comfy, concrete, barbed wire fenced place. But as far as whether you get access to religious objects, whether or not you can have baptisms inside, what sorts of protections exist for religious practice, the federal law sets out a fair amount of protection. Even within that, there's a fair amount of interpretive difference. States also do different things within that. Employment, talking about Jordan's organization and the First Liberty Institute, which is taking on a case at the U.S. Supreme Court right now, it's an open question whether or not private employers and public employers have to recognize religious days off, have to accommodate Sabbatarian work schedules, things like that. Some states have already addressed that in different ways. Religious garb has been fairly protected in the workplace at the federal level. But workplace accommodations, again, you want to talk about granular. That's the kind of thing, what sort of standing desk you get and what you can keep on it. I mean, those are very, very particular questions. Next up, public schools. That's a little bit of freedom to and a little bit of freedom from. Maybe it's freedom to for students who might want to say grace before meals, pray before a football game, gather around the flag in the mornings and offer devotionals, right? Make a PA address that involves religious teachings. It might be that would be freedom from, because the students have to be there. Freedom to might apply to teachers and employers. There's been wiggle room and a lot of movement in the federal side of that over the past year, thanks in part to First Liberty's case Kennedy v. Bremerton involving a football coach praying before games. Next up, moving outside of public schools, school choice. That is a place where that Establishment Clause objection gets brought up a lot. That if you're going to pay people for private school tuition at a religious school, that might create Establishment Clause problems. Nevertheless, it also poses a question of discrimination against religion. If you can go to any private school in the state, as long as it's not religious, or too religious, or religious in the wrong ways, Maine just lost a U.S. Supreme Court case because it banned religious schools from receiving tuition money that parents could otherwise direct. Maine then rejected the applications of all the schools that won because of their stances on sexual morality. I see I've got about 20 seconds here, so let me move quickly. Other areas to look at, executive and administrative actions. That was kind of a sleeper issue right up until COVID, when governors decided whether or not the liquor store, the casino, the theater, and the church could be open on any given Sunday. And some legislators did respond by passing new statutes in light of that, concerning religion in particular, and state constitutions, pretty much all of which recognize religious liberty, but each of which has particular wording. And lawyers can do all sorts of things that may be totally out of bounds in the federal context using that. So statutes are important, constitutions are important, fidelity to them is important, interpretations of them are important. So I challenge you to find ways to try to get that down on numbers, and I'll say for the rest, well, the lawyers aren't going anywhere anytime soon. So thank you.
I will have many more responses in the coming months and years from these excellent comments. This has been really helpful, and I've been trying to take copious notes. I'll probably just have a few responses right now, and probably largely to reflect on what we're trying to do in year 2. Definitely some new, very helpful comments here, but some too that we've had some preview from in our review process early on, and so we've been trying even now to make improvements moving into year 2. So let me say right off the bat, because we've been careful to design, I think, a systematic methodology that the index itself, the data set itself, can grow over time as we identify new areas. We're anticipating before the index launched in September that the Dobbs decision, right, which as soon as it leaked, I was on my iPhone probably one morning at 4 a.m. trying to figure out what is this going to do to my index. And we feel pretty comfortable that our methodology is going to be able to account for that. If any of these groups you've mentioned are successful in getting a state law to say because of religious free exercise, we need to provide abortions, and all institutions need to provide abortions, or they have to be legal, we're going to have to do something about that consistent with our methodology. It's probably one of those scary cases where I personally am going to have to score as religious liberty enhancing something that I find counter to human flourishing. But again, we're trying to measure what we've set out to measure, and we're not going to portray this as all-encompassing. We've had other suggestions of new items. We're just in the next 2 weeks, we'll be vetting those carefully. So I won't name any that are contenders for year 2, but I will mention that we have thought about things like religious garb in the workplace, and especially among, let's say, police officers and sheriffs and the like. And this is an area where I think there is variation, maybe even more at a local level than at a state level. But at the state level, really, the federal law should trump what we see in the letter of the law. Now, that's not to say that it always does. It doesn't mean, right, because one of the complications to all of this is people don't always follow the law. Right, and even local governments and state governments don't always follow the law, and so I think no matter how big this index ever becomes, we will need lawyers, and we will need historians, and we will need judges, and we will need various social sciences and people from the humanities to dig into what is going on here, no matter how big our data gets. So we will be considering new items. You can look forward to that, hopefully, in July, seeing what those are. But from the very beginning, we've been especially conscious of the fact that that courts and judges interpret law. And one specific step we've taken in year 2 of this project is to use a very able law student, right? This is way outside of my area of expertise, to undertake updating using citators, to look at each of the statutes that we're citing. So imagine his Christmas break, this wonderful law student, looking at each of those hyperlinked statutes and running through 2 separate citators, each of those statutes reading all of the state level court cases that have been heard that cite that statute. And in this space, imagine a matrix, 1,500 or so cells. 3 came back as superseded by some state ruling. But what we got that I think is going to be especially valuable to people that want to dig in, that aren't just interested in the heat map and thinking about the ranking. Frankly, I think one of the biggest contributions of this project, and I say this with humility, but it's, you know, the sweat of our brows, my research assistant and I just putting together data that didn't exist in one place. Now with this citator updating, we will have notes even beyond those that were court cases that superseded our data items, reflecting where these things have been tested. Right? So in some states, their state RFRA laws have been tested time and time again. And there are just so many different rulings and all of the various ways that they've communicated about this balancing, right, between the state interests and the burden on the religious individual that we'll never be able to quantify. But having this in our data set for other people to dig into, whether it's one state or across 23 states that have RFRAs, will be fascinating. So those are 2 things that are coming. If I can, just by way of segue to what I think will be more general discussion, I wanted to suggest some other ways you can dig into what we've done. And we've really tried to slice and dice the data, not to tell a story, but to make it accessible to different audiences so that you can find it in a way that it's useful to you. So on our website, we have state pages for each state reflecting not just their overall score, that's interesting, but for the scholars among us and legal experts and people with, you know, a desire to dig into, to really wade into the weeds here. Not just what their ultimate score is, here we have North Carolina's scorecard, but how they've managed to get that score. So all of the boxes that they've checked and those they have not. If you're interested in a particular topic area, one of the 11 safeguards we're interested in, we have some really nice, thanks to our web designer, sortable tables that don't just say, yep, they checked this box and these states didn't, but actually tell us how. And then again, those hyperlinked citations so that you can go read the letter of the law. This has been helpful as state legislators have reached out to us and say, how do we do better? Do you have any sample legislation? And I say, I don't believe anyone's written sample legislation, but I can tell you what 5 states are already doing this. Perhaps if you look at those, you'll have a good sense of how to make this feasible for your particular state. For those of us who just would rather see all of it, again, I'll plug the report, but also the data set itself is available in an Excel spreadsheet with those scores, the codes, the citation, the hyperlinks, then our notes as well on how we've made our decision. We did not have the benefit of already available data sets. A lot of index projects take other data sets and compile them and put them together. We've constructed this data from the letters of state laws, and so in some cases we thought people are going to question how did we come to this assessment, and we've included those there as well. So if you're interested in downloading the data set, I would invite you to. And I'll mention again that our next version is coming out July 13th. If you're interested in getting a reminder, go to the website and sign up for an update. But we're looking forward to improving on this project thanks to the feedback we've received, including the things that these folks have shared going forward. Should we take questions now?
So for the rest of the time, we're going to take some questions and have other discussion up here. What I'll do is I'll leave this mic here, and I've got one there that I can walk around with, and then you guys, whoever has something to say, you can just pass the mic down. Again, we do have copies of the full report that are out there on the table, as well as other materials related to the report. We encourage you to pick those up. If you go to the website right now, it's on your phone or on your computer. It's optimized for mobile, and you can check whatever state you're coming from to see where they're at and those kinds of things right now too. So I recommend those resources. But I'm going to hand the mic over and then start taking some questions.
Thanks very much, Sarah and everybody. Really exciting project. Just a general question, I guess, for you as you're constructing the data set, or for anybody. I'm kind of interested in situations where corporate religious freedom might conflict with individual religious freedom. So the ability of churches to discipline their members or something like that. I know there's some litigation about these kinds of issues. You could kind of see that as expanding, freedom from government interference for the corporate religious body, but kind of also exposes the individual to restrictions on his or her own religious liberty, or something like that. Just was curious if you have thought about how to code those things, or just anybody have any comments on that.
Great. Well, I'll speak briefly to how the project would handle that. Since we're defining liberty in the sense of freedom from the restrictions of the state, we won't need to take any kind of angle on whether church discipline is conducive to human flourishing or the like, or otherwise. I thank you for offering that as an example. I know that one of the critiques we've received from some is that it's so much flavored as kind of individual liberties, which I don't know. Maybe there's a reason why it comes out that way when I'm presenting it, sorry, but we're certainly aware of corporate religious liberty as well. The maybe somewhat analogous example that I come up with earlier in the project was thinking about, how are we going to define liberty? Why do we even need to define liberty? I was thinking about anti-discrimination law and employment, which we're not actually covering in our project. You may have noticed a number of areas that we're not covering. And the reason is because of the federal anti-discrimination law, and the space that leaves for states is very difficult to define. And what constitutes an employer, for example. But it was helpful in thinking about, to come up with the example of the Muslim butcher shop owner, and let's say, here's an economist coming up with hypotheticals, a Christian butcher, right? And so whose religious freedom are we interested in? The project has to decide which are we going to look at, because these are competing rights claims, right? And so if a Muslim butcher shop owner wants to actually run a halal butcher shop, it just can't be that the butcher who is seeking employment is willing to follow all the rules. There's actually an element of halal that requires believing in Islam. So you actually have to believe a particular way. He legitimately cannot run a halal butcher shop without having a test on belief. A Christian butcher could then say, but I shouldn't be judged based on my religion, whether I can have this employment. That's what anti-discrimination laws and employment are for. But that claim is actually making a duty to the employer himself. And so for our project, we're siding not because we prefer Islam to Christianity or particular types of meat to other types of meat, but because it's freedom from the state, that we would side with that Muslim butcher. So we have thought about some of those sticky cases where I think we can make arguments that, hey, I would love for a Christian butcher to be able to work where she wants to in her neighborhood, but there are trade-offs, and so we're going to decide on the side of the employer who is not an agent of the state so much as running his own enterprise.
I do, but you go first.
Two things that I will note. Number one, the United States has generally treated your right to disassociate with somebody as an important liberty in and of itself. So you have the right to choose who you associate with within an organization. That was a U.S. Supreme Court case involving the Boy Scouts back in the 1990s, brought by a gay scoutmaster who argued that that was discrimination that violated a state law. The Boy Scouts responded with First Amendment rights to speech and to expressive association, and the U.S. Supreme Court sided with the Boy Scouts in that case. There was a similar case involving Boston's Irish parade for St. Patrick's Day and a gay group that wanted to march in that. That does conflict with the ways that some other countries handle this. So a Dutch court recently fined the Jehovah's Witnesses for disfellowshipping somebody on the ground that it violated that individual's right to associate positively with other people. The United States has generally put the negative liberty forward first and said that you have the right as a group or as an individual to select who you associate with. And that, in fact, it is an important part of your individual liberty to belong to a group that doesn't include everybody. And so if you have, again, a Jehovah's Witness chapter, for example, and for whatever reason that group decides to exclude somebody, as long as that group is not engaging in commercial activity, and that is where the United States Supreme Court has drawn the line. The Junior Chamber of Commerce had a case, and there were cases involving New York social clubs that were basically networking commercial organizations. The U.S. Supreme Court upheld anti-discrimination laws as applied to them. But generally, you're right, within a purely private context, to disassociate has been held to be part of your individual liberty. Number two, what might be more measurable, though, is what doctrine of church autonomy a different state has adopted. When there are disputes around property and around dissolution of a church community, different churches have different internal rules about that. Some more congregational models, it might be that congregation, and if they vote 51% to leave the broader denomination, under church law, everything belongs to them. That is not true of Orthodox churches, of Catholic churches. I mean, capital O, Orthodox, right? Hierarchical, there you go, St. Vladimir's guys over here. But a hierarchical church, that would not be true under canon law. Some states will defer to how a church structures its own internal or a religious organization. I keep using very Christian language here, but truly these things do apply outside of that context. Some will defer to the religion's own understanding of internal organization. Others allow a court to apply what are called neutral principles of law to sort that out. The U.S. Supreme Court so far has said both are allowed. But that can have a major impact, and there have been cases recently involving disputes within Orthodox ecclesiology. The United Methodist Church's impending split is about to set off an entire another round of litigation. Who keeps the churches? Who keeps the pews? Who keeps the endowments? And that is something where there's a question of freedom from the state determining for you how you're going to have your property disputes resolved. So that might be worth exploring.
All right, well, you had me with corporations. Since the Hobby Lobby decision, law professors on the left have been mocking the idea that corporations should enjoy religious liberty or freedom of speech or this sort of thing. That case, of course, involved the Obamacare mandate to provide abortifacients to women at no cost to the women. The corporation had to do this, and they brought their case based on the Religious Freedom Restoration Act. Unfortunately, 5 justices agreed that you can't compel the corporation. Let me just point out, it goes to Sarah's hypothetical, there was a non-hypothetical right along these lines. There was a series of cases right around 1960 involving challenges to Sunday closing laws. One of these was brought by a Jewish delicatessen, which was incorporated. No one suggested that this corporation could not bring a case and should not be protected by the Free Exercise Clause. Justice William Brennan thought it should be, right? One of the most famous cases any law student will study is a New York Times company versus Sullivan. No progressive I've ever met has suggested the New York Times company, a corporation, should not be protected by freedom of speech. So I just point that out to say I think generally the courts, I think they got the Sunday closing case wrong, but generally there's been an understanding that corporations as well as individuals are protected by the Free Exercise Clause, freedom of speech, and so forth.
Thank you. I'm grateful for the capacity to continue to excommunicate, as is our history. I'm a philosopher, so I probably have more in common with the lawyer and the desire to think abstractly. You had brought up this issue of perhaps eventually having to support things like abortion under religious liberty. And it brings up this question in my mind that we see sort of new atheism has lost, and we're seeing a rise of neo-paganism, Wicca, especially of a feminist variety, and so on, and already in some circles ritualized abortions. will sort of the defense of religious liberty eventually entail some absurd conclusion that we will be, in some sense, forced, or at least allow things like abortion or even gender transitions or any of these other, or maybe even, frankly, human sacrifice? I mean, if it's consensual, if it's ritualized, and it can fall under these sort of same strictures or protections or from or to or however. What do you all think about this? Is it even a live question? I mean, is it, or is it like, oh no, that will never happen? Thank you.
Well, historically, we always had peace and safety exceptions to free exercise. The most famous case is the Reynolds case. That's the polygamy case from 1879. And the Supreme Court struck down that religious practice. That's a sincerely held belief, or it certainly was at the time. And it relied on an old doctrine that had been in the courts for many, many years. Your limit, or the government's limit on acting in the religious realm is when a practice endangers the peace and safety of the community. So you might see a revival of that concept. Ritualized abortion could well fall under the peace and safety exception. That would be my response.
I would add, so strict scrutiny means that the government needs to have a compelling interest. The life of unconsenting third parties or their physical safety has always been held to be a compelling, I mean, that is like ground zero, the compelling interest. So I think a state would, by and large, succeed in arguing to a court, as long as they can establish that the state truly believes that life begins at this point. I think it would be difficult for a court to say, nah. South Carolina did have this come up recently, though, under the state privacy clause. The state attempted to pass a 6-week ban on abortion, arguing that that would allow for room for abortions once people realized they happened, that there would still be a small window to allow it. And the court said that that was the state's way of actually disavowing a compelling interest in protecting all life. One justice said, if this was a 0-week ban, I would have voted to uphold it. So that is tricky. I don't know how many courts are going to micromanage to that extent. I would assume many would not. One more note about some of the cases that have been brought. Sincerity is a threshold matter that a religious claimant has to establish in a court. Now, that is something that most courts are pretty unwilling to tread too heavily into. Courts are not meant to be inquisitorial about whether or not somebody really believes it. The U.S. Supreme Court has said your beliefs do not need to be logical, consistent, shared by others, so on and so forth. Nevertheless, I have to point it out, the Satanic Temple, or the Church of Satan, or whichever one it is, about half of the satanic groups that have brought religious liberty claims around abortion at least appear to have a colorable, sincere belief that they are compelled to do things in honor of higher powers. The other half are fairly clear that they are some degree of satirical on religion and some degree of philosophical groups that have strong opinions about separation of church and state. That second camp is, I think, actually ripe for sincerity pushback. I think that they will actually have a difficult time establishing that. Jewish plaintiffs, depends on the context. Now, I'm not an expert in Jewish law. From what I have seen, there are some Jewish plaintiffs who could establish that they religiously believe under certain circumstances that they have to have an abortion. There are a lot more who say our religion allows us to have an abortion and that's why we're suing. Just because your religion allows you to do something does not mean that you have a substantial burden on your practice because of a government law banning something. So that's also something that's going to get sifted out. Again, that's not to say that all of those claims will fail, but that is going to be in the mix in some of these cases that come up.
I just had a slight question more about people who have idiosyncratic beliefs. Like you mentioned, the Supreme Court talking just not about anybody sharing that, and whether it's better to talk about like a conscious objection as opposed to a religious objection, because at least to me a religious objection seems to be a belief shared by, at least your local congregation, as opposed to like whatever that congregation is, whether it's a a synagogue, a Muslim mosque, whatever, a Catholic church. And I think this comes up sometimes when people have like conscious objections to certain things. And I could think as a theoretical, let's say that there's a Catholic vegan, and the school is like, we're going on a field trip, we're providing ham and cheese sandwiches to everybody. The Jewish, no matter what day of the week it is, could say, no. The Catholic could say, well, it's Friday. We even though the church doesn't require it, we're strict. We follow the stricter rules, and we don't eat meat on Friday in our family, so we're going to send our kids something special. But like on a Tuesday, you can have a conscious belief that you're a vegan and not eat meat, but I don't see a religious belief in that sense. And that's at least my understanding is like, and is that really in law, or is law just all of it religious and no conscious exemption? Because I'm not a lawyer at all.
U.S. Supreme Court had a case back in the 80s of a Seventh-day Adventist, 70s or 80s, who was working at an armaments factory and left that work because he didn't believe he could work on tank turrets. He then sued for unemployment compensation and was denied. He said that he was fired for his religious beliefs. The state presented all kinds of affidavits from Seventh-day Adventists saying whatever pacifism we may have or not, it doesn't extend to manufacturing tank turrets, so he should be out of luck. Supreme Court said, at the end of the day, religious free exercise is an individual right. It can go to how likely it is that you're sincere if you say, my entire religion revolves around wearing purple shirts. By golly, nobody else believes it. Okay, there might be a sincerity inquiry that comes up there, right? But the United States Supreme Court has held that you do have the ability to assert idiosyncratic claims, even if other people within your religious community do not agree with them. It is an individual right, and it has been defined very broadly. Now, in some defense of that, especially from a Catholic angle here, the church has said that you do not need to be a pacifist. The church has said that the just war tradition exists. St. Augustine, St. Thomas Aquinas, you can, in good standing with the hierarchy, do that. The church has also said, though, that you do have the ability as a believer to go beyond that and strive for evangelical perfection through pacifism, and that the church would support that. Same thing in the vaccine context. The church has said you can have any of the COVID vaccines. Even though there is some involvement with abortion-backed research, it's attenuated enough where you do not need to do this. The church has also said you should protest that came from the abortion context. And if you choose not to, and you are not in a situation where you gravely have to protect yourself and others, right, you are entitled to make that kind of religious claim. So, should it be more communitarian? Certainly some countries, it is more based on, you gotta link it up. Some countries make it very easy administratively. Indonesia recognizes 5 religions. If you're in one of them and you can point to a belief, you're off the ground. If you cannot, you don't get it. The United States has shown more flexibility around that. I think especially given that not all religions are super hierarchical, given that some take the primacy of conscience to very, very, very strong degrees, right? It's one thing to say, all right, well, you're a Catholic, the bishops don't say you have to be a vegan, so what? It's another to say, I mean, if you are a low church independent Baptist, who do you even look to? You haven't convinced 5 others to agree with you and sign a document. And so there's pickiness around that. I think there are strong reasons for the more individual approach that we have. But, yeah.
Let me just pick up on the conscience versus free exercise of religion. If you look at the amendments that were proposed after the Constitution was ratified, as Congress was considering how we might amend it, some of the amendments literally would have provisions saying the freedom of conscience shall not be infringed upon, nor shall the free exercise of religion. So you had this simultaneously in the same place, conscience and free exercise of religion. That conscience language was dropped out. And I think you look at other statutes. I mentioned the Rhode Island statute that clearly protects all conscience claims. Very rapidly, most of the other colonies were far more narrow. They said you have to be a Quaker pacifist who objects to all wars in order to be protected. If you push forward to some of these medical protection laws that started being passed in the 1970s, I think very appropriately they protect people who object to abortion for religious or moral reasons, thus protecting conscience as well as religion. But in so many ways, Brian Leiter, to the contrary, religion is special. The free exercise of religion is specially protected. To this day, Congress only protects religious pacifists who object to military service. Now, I think those protections should be extended to all conscience claims, but I think that should be done by the legislature, not creative statutory interpretation on the part of U.S. Supreme Court justices.
Just to go back to the point about individuals versus institutional or corporate interests, Sarah, a number of the 29 safeguards you've identified are related to individuals in certain circumstances or employment contexts, but a number of them do relate to institutions as well, right? You mentioned public hospitals or private hospitals as well. There's a statute in Mississippi that's unique that you've identified there. So do you want to say a little bit about what you've actually identified in the states with respect to safeguards for individuals versus institutions?
Yes, sure. So we have religious employers, the exemption within the contraceptive mandate. There is a federal exemption, but states can functionally reduce that space by having their own state-level contraceptive mandate. And so that would be for employers, which could include corporate sorts of things, right, groups, and not just individuals. But certainly within our marriage and wedding safeguards, there are religious organizations. This is really important, even with the, we've been paying close attention to the Respect for Marriage Act that was signed into the law at the end of last year. At the federal level, that religious organizations, which throughout law, frankly, we need to keep a close eye on how those are defined, right? Within a lot of states, to be religious, you have to have as your chief mission inculcating a religion. And so if you are fundamentally a poverty ministry, but you come from a perspective of faith, you don't count as a religious organization in those kind of states. So we have paid close attention to that in marriage and weddings in terms of facilitating or participating in marriage or weddings that would go against doctrine. And then, of course, the RFRA law is a mixed bag, as we've heard from many people, right, in the sense that it seems very umbrella as a protection to not, substantially burden religious people, including right groups, but perhaps when balanced against the interests of the states doesn't hold a lot of water, but that is, because it is so generalizable, is another way that we've captured protections for groups. Private hospitals, public hospitals. In fact, you might be interested to know that the three real eye-opening bits of feedback we got from the legal citator updating were 3 state-level court cases on whether public hospitals could refuse to participate in abortion. In 3 different states, those states have superseded the letter of the statutory law on those. And so those clearly were some hot-button issues. Jordan, can I, since I have the mic, can I respond a little bit more to abortion? As I kind of tipped my hat to, I think in the hypotheticals and even in terms of the kind of just the discourse we have these days, I do personally worry about a time where the idea that a religion could actually ritualize abortion, right? It frightens me some for what might come years down the road. But one thing that I've been really encouraged by is that careful approach to trying to quantify what it is that we mean to measure has us in a situation post-Dobbs where I think we're able to really add to a realistic understanding of what Dobbs has and hasn't accomplished. So we have a number of items related to abortion refusal, as I mentioned. There is a narrative coming from more progressive camps that in some states abortion is illegal. They say, right, it's illegal in, this handful of states. Abortion is not illegal in any state. There are abortions being performed in all states. There are always exceptions. And so because of our careful methodology, I feel very comfortable saying as long as there is any chance of a person seeking an abortion, the ability to refuse participation for religious people is important. And so I found that encouraging for the fact that I just feel like we have a very principled and careful, systematic way of addressing this. And I think that reality should be helpful to people that do want to argue against expanding abortion rights or abortion in general, to say, hey, let's knock out this narrative that somehow now abortion can be or is currently illegal in any state, because that's just not the reality of the situation.
Well, join me in thanking the panelists and Sarah and everybody for their participation. Thank you for your questions.
I just want to thank Jordan Baller and our panelists and for the CRCD for bringing this panel to us. It's really important work that they're doing, and I remember when I first heard what Sarah was up to, I was like, oh, this is going to be big. And that she's definitely delivered on this promise. So essential work, especially in educating lawmakers and ordinary citizens about the state of play, that often goes unnoticed until it comes down on your head like a ton of bricks after the policy and judgments have already been made. We're going to have lunch, but before we have lunch, we'll have a prayer. And during lunch, Professor Wasaki will let you know about the breakout rooms and where they are. You do not want directions from me. I do not. Psalm 122 or 123. As I live, says the Lord, I have no pleasure in the death of the wicked man. Rather, let him turn from his evil way and live. To you I lift up my eyes, to you who dwell in the heavens, like the eyes of a servant watching his master, like the eyes of a maid on her mistress's hand. So we keep our eyes on the Lord our God as we wait for his kindness. Take pity on us, Lord, take pity. We have had our fill of contempt. Our souls have had their fill of the laughter of the rich, of the contempt of the proud. Glory be to the Father, Son, and the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Purify us, Almighty God, through our wholehearted endeavor to renew our lives, so that we may approach the coming festival with single-minded devotion through Christ our Lord. Amen. Remember, it's Friday, all right? So leave the ham to the Protestants.